Colorado just pulled the pin on a legislative grenade, and most of the country still hasn't heard the bang. One signature from Governor Jared Polis will, in 14 months, turn a perfectly normal trip to your local gun shop into an obstacle course of fees, fingerprints, and government tests. In this video, we'll talk about Senate Bill 25-003, why it's a Trojan horse aimed straight at nearly 2 million lawful Colorado gun owners, how it builds a backdoor registry, and what you must do right now if you don't want to wake up a criminal on August 1st, 2026. The bill's official title drones on about prohibitive activity involving semi-automatic firearms, but Sheriff Jason Mikesell from Teller County boiled it down in plain English. The state wants sheriffs to decide who deserves to buy most semi-automatic rifles, shotguns, and even pistols. That's not hyperbole. Unless your pistol is just a lowly .22 LR, or your rifle is one of roughly 40 sporting rimfire or bolt-action models that lobbyists manage to slip onto an exemption list, you'll need a golden ticket called an eligibility card. No card, no purchase, no transfer, no sale, period. The bill also bans any future sale of rapid-fire devices, just to make sure nobody imports a workaround. Legislators swear it isn't a ban, yet the muzzle is pointed at every detachable mag semi-auto in the state, which is most of the modern market. Colorado has about 5.9 million residents. Roughly a third, over 1.9 million souls, own at least one firearm, and researchers estimate there are more than 7.7 million privately held guns tucked into safes, glove boxes, and nightstands from Fort Collins to Durango. 45% of adults live in a household with a gun. Those citizens passed federal background checks, cleared the state's own waiting periods, and obeyed the 15-round magazine limit that politicians rammed through in 2013. Now, the same politicians insist those citizens can't be trusted to buy another common semi-automatic without first paying tribute and passing a written test that the state can change any time it feels like tightening the leash. The permit scheme works like this. First, attend your sheriff's office, fill out the application, give up fingerprints, and wait for a background check that duplicates the federal NICS you already cleared. The sheriff may deny you for any danger to self or others, a phrase so elastic it can wrap around anything from a dismissed misdemeanor to a decade-old prescription for anxiety meds. Pass that hurdle and you get a course eligibility card, the golden ticket, good for 5 years. Step 2 is a mandatory safety class, approved by Colorado Parks and Wildlife. If you've got a state hunting license issued in the last 5 years, the class is 4 hours. If not, saddle up for 12 hours of classroom and range time. When the class ends, you face a written exam. The concealed carry permit test only demands 80%. The eligibility exam requires 90%. Sheriff Mikesell's firearms training commander calls that buying your rights back, one quiz question at a time. Proponents argue the course fee will stay under $200, yet the bill lets Parks and Wildlife set the price and shovel the proceeds into discretionary accounts. Nothing stops the agency from cranking the cost higher once the program is in motion. Counties must staff extra clerks, deputies, and instructors to fingerprint and process tens of thousands of applicants. Teller County alone expects to hire 10 new employees and eat an unfunded $500,000 expense in year 1. The state sits more than $1 billion in the red already. Taxpayers will cover the shortfall, while permit fees flow into coffers that politicians can spend on anything from wildlife brochures to urban rail lines. The registry angle is impossible to ignore. Every eligibility card ties fingerprints, driver's license data, and firearm purchase records to a state database. Advocates insist it's merely proof of training, but the sheriff in the video calls that nonsense. Once a central list exists, any future legislature or any overeager bureaucracy can sort, print, and cross-reference it with a keystroke. It's a slow-motion replay of California's rifle registry, New York's SAFE Act, and Canada's long gun fiasco. Promise the public it isn't a registry, build one anyway, then tighten the screws later. Buy once, cry every 5 years when renewal rolls around and new restrictions slide through under cover of administrative updates. Defenders of the bill wave off those concerns and cite a carve-out for pre-August 2026 owners. Keep your existing guns, they say, no problem. That reassurance crumbles on contact with reality. Try to sell your grandfather's 1911 to a neighbor after the cutoff, and you'll both need eligibility cards. Fail the test? Your heirloom freezes in limbo. Want to replace a worn-out barrel on your favorite AR or trade up to a new shotgun? Permit first. Permit lapses? The same firearm that sat harmlessly in your closet for 15 years turns you into a Class 2 misdemeanor if you cross county lines to hunt turkey without the paperwork caught up. A second lapse becomes a Class 6 felony. Felony status vaporizes your gun rights nationwide and haunts every job application and apartment lease for the rest of your life. Sheriffs are furious at being cast as gatekeepers. They already run jails, patrol thousands of square miles, and process concealed carry permits. SB 25-003 dumps record-keeping for a brand-new card system into their laps, demands they store fingerprint files, and forces them to decide who is dangerous. In urban counties likely to embrace the law, sheriffs may rubber stamp cards for politically favored groups while slow-rolling rural residents. In conservative counties, an elected sheriff sympathetic to the Second Amendment could refuse to participate, but then the state will threaten funding, sue, or appoint a compliance monitor. Either way, politicians in Denver win. Compliant sheriffs build the registry, resistant sheriffs bleed county budgets dry. Businesses also get hammered. Every FFL in Colorado must register with the state, buy a special dealer license that costs double the federal one, and swallow a new 6.5% excise tax on every sale beginning April 1st. Add SB 25-003 on top, and you have a vice squeezing the supply side. Shops will close, inventory will migrate to Wyoming and Utah, and the state will lose both sales tax revenue and good-paying jobs. Lawmakers know this. They want it. Controller Bonalik from Teller County spelled it out. The real aim is to suffocate the gun industry, not just limit ownership. Supporters claim crime will drop. Data disagree. Colorado's violent crime rate has climbed to the top tier nationally, despite earlier magazine limits, red flag orders, and mandatory locked car storage rules. Criminals ignore paperwork. They steal guns, buy them on the street, or file the serial numbers off stolen ones. The new eligibility card demands 90% literacy on a multiple-choice sheet. Yet carjackers in Aurora will never see that sheet. They're busy ripping lockboxes out of SUVs, a stupidity sheriff deputies predicted when legislators required visible lockboxes in vehicles last year. Make citizens more helpless, watch crime surge, then rinse and repeat with another bill. Public hearings on Senate Bill 25-003 turned into circus acts. Rural residents drove hours to denounce the proposal, but Judiciary Committee chairs limited testimonies, shuffled the order, and cut microphones. The bill squeaked through the Senate 17-15, then rolled into a House that holds an even larger progressive majority. Amendments watered down a few clauses during negotiation with the governor, yet every veteran of the Capitol knows the House floor can strip amendments at the 11th hour and pass the original language intact. Even Polis appears unsure. He mutters about keeping class fees low and exempting retired cops from redundant training, but his pen is ready if the House drops the bill on his desk. Opponents aren't waiting on the governor's conscience. Rocky Mountain gun owners filed preliminary injunction paperwork the day SB 25-003 cleared committee. National groups such as Firearms Policy Coalition and the NRA plot parallel suits that lean on Bruin and Heller precedents. Litigation takes years and costs millions. While courts crawl, the bureaucracy races ahead. That gap between filing suit and winning relief is the danger zone where ordinary folks accidentally break brand new rules they never heard about because legacy media framed the law as harmless gun safety modernization. So, what can a Colorado gun owner, or any American who sees their own legislature salivating over this template, do right now? First, read the bill. It's only 18 pages, plus amendments, but every comma carries legal weight. Know which firearms you own that fall inside the new net. Second, call your county sheriff. Ask whether the office plans to issue eligibility cards and what resources they have for classes. If the sheriff values the Second Amendment, volunteer time or range space to help train neighbors before wait lists explode. Third, stash cash. Permit, fingerprints, course, ammo for the live fire section, day off work, fuel to drive to the nearest instructor. That pile could top $300 per person. Families with multiple adult shooters face quadruple costs. Fourth, buy any semi-auto you might want before August 2026, as long as you can do so legally. Waiting means risking price spikes, inventory shock, or outright scarcity when retailers see the handwriting on the vault door. Fifth, testify. The House Judiciary livestream opens public testimony slots online. Fill one. Speak plain English. Lawmakers bank on apathy. A flood of voters on record makes it harder for moderates to shrug and vote yes. Sixth, donate. Court fights hinge on filing fees, expert witnesses, and appellate briefs. $200 tossed at a state-mandated class might buy more freedom if redirected to a lawsuit that could nuke the entire statute. Seventh, spread the word. Forward the Teller County Sheriff's Office video to friends who think it can't happen here. It is happening here now. Some folks ask whether moving is an overreaction. Maybe not. Mobility is a right the government hasn't taxed yet. Wyoming, Utah, Idaho, and Arizona welcome gun owners with fewer strings attached. A U-Haul costs money, but so does losing fundamental rights one background check duplicate at a time. The choice will differ for every family. At a minimum, watch property values. A house that backs up to prime elk country loses luster if nearby shooting range is close, and semi-auto bans crush local retail. This rant is not a salesman's pitch. I don't make a nickel if you buy a rifle, sign up for Hunter Ed, or donate to a lobby. What matters is freedom surviving another generation. Our grandparents could mail order a Garand through the DCM for $28. We can't. Kids born this year may never know that America once trusted ordinary citizens with ordinary rifles. The slide toward permit-to-purchase schemes began on the coasts and now reaches the Rockies. Delay, expense, and paperwork are the new muskets stacked outside Lexington Green. National gun control groups applaud SB 25-003 because it takes the California model and bolts it onto a purple western state. If Colorado falls, Nevada, New Mexico, and Oregon become low-hanging fruit. Washington already demands a training certificate for semi-auto rifles. California and Massachusetts require training for any gun. Connecticut likes the idea. Illinois is flirting with it. Politicians read polls showing suburban voters nodding when they hear common sense safety. They omit details about fingerprint files, 5-year renewals, and 90% tests. They also omit that no peer-reviewed study has shown mandatory training courses reduce violent crime when background checks already exist. The sheriff in Teller County made another blunt prediction. Non-compliance will soar. Owners won't register heirlooms. Collectors won't liquidate inventories at fire sale prices. Recreational shooters will run ammo through pistols they technically shouldn't have under state law. That silent protest births a brand new class of paperwork felons. The law will rarely be enforced at a traffic stop in rural Gunnison, yet the record sits on the books. La Plata County deputies trying to follow up on a restraining order call could find themselves ordered to seize guns from a citizen who missed a renewal deadline. The citizen, once peaceful, suddenly faces prison. That clash, not safety, is what worries constitutional sheriffs. Critics call this doomsaying. They point to other regulations and claim the sky never fell. It didn't fall because gun owners adapted, lawyers sued, and courts slapped down the worst bits. Yet each cycle of restriction ratchets the starting point tighter. Colorado's 15-round limit began at 30. Now politicians circle back to the same rifles, wrap them in permission slips, and present the scheme as moderation. The next legislature could drop the round limit to 10, then to 5. Then, why not? Ban detachable magazines altogether once the registry shows who owns what. Anyone spotted at the range with a non-compliant part would face immediate confiscation because the database proves they weren't granted an exemption. That is the danger polite gun owners hesitate to admit aloud. Registries kill freedom. Every regime that disarmed citizens began with a list. American culture used to mock that path as foreign tyranny. Today, legislators cheer it as administrative efficiency. They forget, or deliberately ignore, that freedom is messier than control and more important than comfort. A right taxed and tested every 5 years becomes a regulated activity that surpasses our driver's license levels of scrutiny. Yet driving isn't mentioned in the Bill of Rights. So here we are, Colorado in the crosshairs. Almost 2 million lawful owners, nearly 8 million guns, 45% of households, 300 licensed dealers, and hundreds of instructors scrambling to understand rules drafted by people who can't define gas-operated. If SB 25-003 survives court challenges, that infrastructure starts shrinking. Fewer dealers means longer drives, higher transfer fees, and emptier display cases. Fewer instructors means course bottlenecks and price hikes. New shooters give up, veterans leave, Local ranges close, and the culture thins until regulators claim victory over declining participation they engineered. Tell me in the comments if you're preparing for an eligibility card, planning a last pre-deadline purchase, or looking at property across the border. Slam the like button so the algorithm shows this warning to every Colorado shooter who still hasn't heard. Share it with the out-of-state buddy who thinks his legislature could never copy this madness. Subscribe and ring the bell for updates. Stay vigilant, stay informed, and stay free.